Well, good afternoon to you all, and welcome to this afternoon's seminar, which I've been asked to tell you is being recorded, as we just heard on that recorded message. Before we commence, I confirm that notes of today's seminar, along with various links to guidance notes, arbitrator standards, etc., shall be made available to you tomorrow via an email link that will be sent, from which you can then download. This is in addition to a 3.5-hour 50 multiple choice questionnaire online examination that you'll be invited to sit, the pass mark for which is 40. And yes, that will be followed, that'll be provided via a link as well. Do you want to introduce yourself, Bob?
Certainly, yes. Well, looking at all the names there, most of you already know who I am. I certainly know who a lot of you are. My name is Robert Slavinsky, Chartered Arbitrator, Adjudicator, and PCA Arbitrator. Looking, and of course, Barrister. Now, looking at the names before me, it looks like most of you will have been on the PCA list, if not with the Chartered Institute, with the RICS previously. For those who weren't, welcome. For those who are, I suspect a great deal of what you're going to hear you already know. But as you know, the PCA asks that the new list, the people on the new list, and it is a new list for everybody, go through this training so that we are all on the same page when we're dealing with these PCA arbitrations. Unless anyone wants a long biography of myself, that's all I think I need to say. Nigel.
I would just add that I'm also a Chartered Arbitrator and a PCA Adjudicator Arbitrator. So if we have nothing more, could we have the next slide, please, Christina? Slide 2. So as you can see, is that slide 2? Yeah, could you add slide 2? Okay, so there we go. Just take a little time to appear on my screen. So as you can see, we have an agenda to work through over the next, or between now and 5:30. The idea, our intention is to have a break at 3:30 for 30 minutes and then to return for the final 1.5 hours. So running through this slide, we'll introduce you to the pub code statutory framework. My apologies to those who are already practitioners, but the objective today is to bring everyone up to the same level. As I say, we're going to introduce you to the pub code statutory framework. We'll set out the pubs code arbitration process in terms of looking at the aims and principles of the pubs code, the MRO and non-MRO disputes, treatment of costs, PCA advice and guidance, high court judgments, etc. We'll also look at a couple of worked examples that have been published by the PCA. Hopefully by that point, we'll reach the time for break around 3:30. And then when we return, where we'll look at the considerations specific to the pub code statutory arbitrations. We'll have a comprehensive review of the arbitrator standards, bring to your attention some changes, and look at new and upcoming developments. And at the close of play, we'll have a summary and recap of the learning outcomes. In your notes that you will be provided after today, you'll find at page 4 a table of commonly used terms and abbreviations, which will be used during today's seminar. Since you will not receive those until afterwards, I'll just raise some of the key terms for your attention now. So we'll refer to the CIArb rules. Those are the CIArb's rules which were published on the 1st of December 2015 and are available on the CIArb's website, a link for which will be included within the written materials. When we refer to the code, we are referring to the pubs code, etc. regulations 2016 as amended. If we refer to fees regulations, that's the reference to the pubs code fees, costs, and financial penalties regulations 2016. If we refer to FOT in the documents or by slip of tongue, we are of course referring to free of tie. There's also reference to the IA, or the independent assessor, and that is someone who meets the criteria set by the PCA for independently determining the market rent of an MRO option. So we can see Code Regulation 37.1. We refer also to MRO, which of course stands for market rent only. And in terms of market rent, well, that's the estimated rent it would be reasonable to pay to occupy the premises under an MRO compliant tenancy. That's based on the assumptions in section 43.10 of the SBEE Act. Now, what is the SBEE Act? That is the Small Business, Enterprise and Employment Act 2015. So we just abbreviate that to the SB Act to make it a lot easier to get through today's seminar. In addition, we'll make reference to the MRO rent. That's the rent payable or money payable instead of rent in relation to a tenant's occupation of the premises under the MRO compliant tenancy. Now, we refer to tenants. Sometimes you'll receive that as abbreviated to TPT, which is the tied pub tenant. There's also the MRO option, and the option of the tenant to occupy the tied pub under an MRO compliant tenancy and to pay an agreed rent between the pub owning business. Now we abbreviate pub owning business to POB, and you'll hear us today make numerous references to the POB. So that's the pub owning business. And as I say, it's the agreed rent between the POB and the tenant in accordance with the MRO procedure. The MRO procedure, well, these are steps that must be followed in connection with the offer of the MRO option once the POB receives the tenant's MRO notice. Regulation 39 of the code sets out the circumstances in which the MRO procedure will end. And then there's the MRO notice, a written notice the tenant gives to the POB when an event providing a gateway to the MRO option as set out in the code occurs. You can see regulation 23.1 of the code. Additional jargon, just to make sure that you're all up to speed before we launch into the crux of today's seminar. We also make reference to the MRO for response. And that's a response under regulation 29.3 or 4 of the code, confirming whether the POB agrees to the tenant's description of the event which provides the gateway to the MRO option. There's also, we make reference, of course, to the PCA, and it's a fortunate point where we can actually just confirm that the pub's code adjudicator is Fiona Dickey, and she is responsible for monitoring and encouraging the compliance with and enforcing the code. We also make reference to the resolution period, and that's the period beginning the date after the POB provides a full response to enable the tenant and the POB to negotiate the MRO offer. The resolution period is for 3 months. The tenant can end it earlier by giving 7 days notice to the POB, and it cannot be shorter than 21 days. I've also made reference to the Small Business, Enterprise and Employment Act, so I'll skip past that. And then there's also the update period of a response. So that's a 7-day period at the end of the resolution period, during which a POB may provide an updated full response. So if we could have slide 3, please, Katrina. So by the end of today's training and successful completion of the exam, all arbitrators recommended by the CIArb will have demonstrated knowledge of the code and the workings of PCA statutory arbitrations. On this basis, they should be competent to deal with the PCA cases in line with PCA standards and timeframes. The proposed learning outcomes for today's half-day seminar are as follows. is to understand the pub code statutory framework, including the aims and core principles of the code and a hierarchy of laws, including the distinction between MRO and non-MRO disputes and the applicable time limits. We also want you to identify relevant considerations specific to the pub's code statutory arbitration scheme, including the treatment of costs. Want to know what is required to adhere to the pub's code arbitration standards and the reasons for this, and be aware of existing PCA advice, guidance, High Court judgments, and where to find future publications. Most of this information and what we bring to your attention today can be found within the pcas.gov.uk website, the address for which is within the notes to be provided after today's seminar. If we could have slide 4, please, Katrina. So, following today's seminar, attendees will be invited to sit the 50-question multiple choice examination, as I referred to at the beginning. And we strongly encourage you not to rely upon the notes alone and to undertake broader reading, particularly where indicated within the seminar notes. Could we have the next slide, please, Katrina? Could we have slide 5? So, the pub's code framework is the law that governs the relationship between the tenant and the pub owning business of 500 or more tied pubs in England and Wales. The code was introduced because of a series of serious concerns about the relationship between large pub companies and their tenants. Evidence of significant problems in the industry focus on the treatment of tenants and the share of reward gained by pub owning companies owing to inequalities of bargaining power. Select committees received repeated reports of delay in opening rent review negotiations, lack of transparency in such negotiations, failure to carry out repairs agreed when a tenancy began, verbal agreements being ignored, and harassment of tenants when they were vulnerable through bereavement. The pub code covers pub companies with 500 or more tied pubs, as I have already said, and these are Admiral, Green King, Marston's, Punch Pubs, Star Pubs and Bars, and Stonegate, which is a trading name of EI Group. The code introduced various information and transparency duties on the regulated pub, including 1, pre-tenancy information, including an analysed and evidentially supported rent proposal on which the tenant could then seek professional advice in making a business plan, and which the pub must consider sustainable before proceeding further. 2, another analysed and evidentially supported rent assessment proposal before the rent is renegotiated mid-term. This must take place at least every 5 years, and where the code provides an entitlement, such as where there's been a significant increase in price or a significant impact on trade according to the code definitions, they shall apply. Pubs are also obliged to provide information on taking out or renewing premises insurance with a price matching entitlement. The 4th, there is an obligation to clearly record and update the condition of the property in a schedule of condition. And 5th, negotiations with the pub's representative in respect of rent, repairs, and business planning must be accurately recorded by the pub for the benefit of the tenant. The pub must ensure that its representative deals with the tenants fairly and lawfully. You'll hear that phrase repeatedly in the documents in today's seminar, where we talk about the tenant being treated fairly and lawfully. The code also gives the tenant the right, when renegotiating the rent, to ask the MRO, i.e. the free of time option, more of which we'll discuss later. The pub's code framework includes key elements, including the following. Well, first of all, the SB Act, that's the Small Business Enterprise and Employment Act, 2015, Part 4. The SB Act set up the PCA and introduced the right for a tenant to go free of tie, known as the MRO option. Tenants whose rent review or lease renewal falls after the introduction of the code can request an MRO option, known as the trigger event. Under the pubs code, there are various triggers that enable a tenant to serve an MRO notice. The purpose of introducing the MRO option was to align pubs tenants' rights with those of the traditional commercial tenants and remove the interference from landlords about how their business could be conducted. The landlord's responsibility for insuring the buildings remained unchanged. The service of the MRO notice starts the MRO procedure, the timetable for which is prescribed by the code, more of which later. If there is no agreement following an MRO notice, the adjudicator can be asked to make a decision on the terms for a free of tie tenancy, and the level of rent can then be referred to an IA, an independent assessor. The code has also enabled tenants to make referrals to the adjudicator in respect of suspected breaches of the code. Referrals can be made on a number of different bases, an example being where a tenant considers the pub full response to its MRO notice is defective and refers the issue to the adjudicator to make a ruling within the arbitration award. Another part of the framework is the pub code, etc. regulations, which has since been amended by the Small Business Enterprise and Employment Act 2015 and the Pub Code, etc. Amendment Regulations 2020. Today we just refer to it as the code. The code came into force originally on the 21st of July 2016 with the aim of regulating the relationship between the tenants and their landlords, the pubs whose rent the pubs to the tenants and sell tenants tied products. These regulations set out the practices and the procedures that pubs must follow when dealing with tenants. They include the pub's duties if a tenant pursues an MRO option, including the IA process. The PCA wishes to emphasize that these regulations are the meat on the bones of the primary legislation, which provides the legal rights, duties, responsibilities, and processes that must be followed. The adjudicator has powers to resolve individual disputes, in particular on the lease terms following an MRO notice, award redress to a tenant if a breach of the code is found, and investigate widespread abuses of the code. The forms of enforcement available to the PCA after an investigation are to make recommendations, require information to be published, and impose a financial penalty. As a side, the code has also had an impact upon lease renewals of pubs under the Landlord and Tenant Act 1954. The civil procedurals have been amended to take account of the code to provide information as to the contents of the claim form for a new tenancy and the acknowledgement of service and defence where a party is a pub code tenant. Where a tenant has given an MRO notice in a lease renewal context and court proceedings follow, the key point is that the court must consider whether to stay a claim pending the outcome of the MRO procedure. The third part of the framework is the Pub Code fees, costs, and financial regulations. Fees, costs, financial penalties regulations 2016. To which we refer as the fees regulations. The fees regulations set out, amongst other provisions, who pays the cost of the arbitration and the rules around the tenant's exposure to costs. A dispute about an independent assessor determination is an MRO dispute for the purposes of the fees regulations. Therefore, the cost provisions relevant in respect of the MRO dispute will apply. This includes provisions relating to the cap on the amount that a tenant can be ordered to pay in costs. Tenants cannot be ordered to pay above a certain amount except in specified circumstances. The SB Act, the Code, and the fees regulations are thus collectively referred to as the Pubs Code statutory framework. Now, in addition to those three, there is also the Arbitration Act 1996, which many of us are familiar with, hopefully, and the Rules for Conduct of Arbitration. Section 51.5 of the SB Act and Regulation 58.3 of the Code provides that the arbitration must be conducted in accordance with the rules of the Chartered Institute of Arbitrators, or the rules of another dispute resolution body which the arbitrator nominates. Where there is a conflict between the Pubs Code statutory framework and the Arbitration Act, or dispute resolution rules, the statutory framework takes precedence. Arbitration is the mandated dispute resolution mechanism under Section 48 and Section 54 of the SB Act and Regulation 58.2 of the Code, which is slightly unusual. What is slightly unusual for an arbitrator in a Pubs Code adjudication compared to a commercial arbitration is that whereas an arbitrator will have in mind the possibility of a court reading the award, in addition to the parties, of course, in Pubs Code adjudications, the arbitrator is required to consider the needs of the PCA in her office as regulator as well. So with that in mind, where relevant, an arbitration award should contain such information that the regulator may consider should be made known, so that the regulator may consider whether it is appropriate to instigate an investigation for which evidence will be required. Further, the statutory framework prescribes the requirement for applying institutional rules to the conduct of the arbitration. The CIArb rules apply by default, as I say, as per Code Regulation 58.3. So the hierarchy of laws is first the Pubs Code statutory framework, then the CIArb or other institutional rules, and then the Arbitration Act 1996. In addition, a Pubs Code arbitration is a statutory arbitration as defined by the Arbitration Act, Section 94.1. Part 1 of the Act applies to a statutory arbitration as if the arbitration were pursuant to an arbitration agreement and as if the enactment were that agreement, which you can see from Section 95 of the Arbitration Act. It therefore follows that the provisions of Part 1 do not apply to a statutory arbitration if, or to the extent that, the application is inconsistent with the provisions of the enactment concerned. In this case, the Pubs Code statutory framework, as per Section 94.2a of the Arbitration Act. So if we could have the next slide, please, Katrina, slide 6. Turning now to the Pubs Code arbitration process, the Pubs Code arbitration process can be considered under 5 headings: the aims and principles of the Pubs Code, the MRO and non-MRO disputes, treatment of costs, PCA advice, guidance and High Court judgments, and worked examples, case studies. In terms of aims and principles of the Pubs Code, could we have slide 7, please, Katrina? The code is intentionally consistent with 2 core principles outlined in Section 42.3 of the SB Act. First of all, fair and lawful dealing by pubs in relation to tied pub tenants. And 2, tenants should be no worse off than they would be if they were free of tie. Arbitrators should bear these principles in mind when interpreting the code. Now, in your notes, your attention will be directed to the court judgment in EI Group plc versus Clark and another, which is a 2020 case. Excuse me. Now, in that judgment, Miles Justice stated the following. Paragraph 35 stated at paragraph 35, I agree that the arbitrator thought that this provision required that the proposed MRO compliant tenancy must be drafted to ensure the tenant is no worse off under the MRO tenancy than it was under the existing tied tenancy. do apologise. Paragraph 36 continued, the point is illustrated where he said, such an approach ignores, at least in part, the principles of the 2015 Act and the Pubs Code principle of fair and lawful dealing, and the tenant being no worse off as a tenant free of tide. The arbitrator's reference to the tenant being no worse off as a tenant free of tide shows that he thought that a comparison had to be made between the tenant's position under the existing tide lease and its position free of the tide. This is the wrong position. This is the wrong comparison. At paragraph 40, it continued, the arbitrator made an obvious error on the question of law in these passages. Section 42(3)(b) of the 2015 Act does not require a comparison between the tide lease and the proposed lease to determine whether a particular term would leave the tenant worse off than under the existing tide lease. It is obviously wrong in law to regard differences between the two as a benchmark of assessing whether what is proposed is reasonable. So the comparison is with what other tenants could achieve in free of tide. In addition to that, the PCA states that many cases see the POB represented by lawyers and the tenant unrepresented or represented by non-professional support. Under such circumstances, the PCA states that the arbitrator should consider carefully how their arbitration powers can ensure a fair hearing by using inquisitorial powers, which the PCA considers takes the form of taking initiative to ascertain the facts and the law. Under the Arbitration Act, section 34(2)(g), so as to ensure that the imbalance of the power the code was designed to alleviate is not exacerbated in the arbitration process, yet simultaneously bearing in mind not to breach the rules of natural justice or to reverse the burden of proof either. To that end, if areas of unsettled law are in dispute, the PCA considers POB should put forward reasons for any assertion on the interpretation of law they seek to make. However, in relation to the burden of proof, at paragraph 45 and 46 of the judgment in Punch Partnerships and Another versus John Alt in 2020, again, a link is provided in your notes, so don't worry if you didn't catch that. It was stated as follows. At paragraph 45, stated, the arbitration was initiated by the tenant on the basis of a contention that the proposed tenancy was not MRO compliant. The issue was the reasonableness of the keg stocking requirement. The tenant therefore alleged a breach of regulation 29 of the code and section 43(4)(a) of the SB Act. Paragraph 46 continued. On the normal rules of the burden of proof, the onus lay on the tenant to establish the breach alleged. Nothing in the statutory framework set out in the SB Act and the code suggests a reversal of that burden of proof. In those circumstances, if the arbitrator considered that the burden of proof should be reversed, that should have been raised with the parties for their comment. In that matter, the arbitrator had proceeded on the basis that it was for the POB to prove the reasonableness of a stocking requirement, rather than it being for the tied pub tenant to establish the unreasonableness. This judge considered that the usual approach would be for the party making a claim to have to prove that assertion, and the arbitrator should have invited submissions from the parties on the burden of proof before departing from the usual approach. The PCA would like it to be noted that this appeal was decided before the publication of amendments to the Regulatory Compliance Handbook, which require the POB to complete a compliance checklist so that it is able to demonstrate and evidence the compliance of the MRO proposal when it is issued. The PCA is therefore explicitly of the view that the POB should have the burden of demonstrating that compliance before any arbitration can be referred, and has taken regulatory steps to make that clear. Therefore, whilst usually bearing the burden of proof in the arbitration, the tenant should already have available the POB's reasons and supporting evidence for putting forward the MRO proposal as compliant in order to be in a position to advance its case. In the event that, for example, a compliance checklist was incomplete or inadequate to demonstrate and evidence its reasons, the PCA is of the view that it would be open to the arbitrator to consider with the parties the appropriate approaches to managing the arbitration, including where the burden of proof should lie. In terms of the impact of delays in pub code arbitrations, delays in resolving disputes often undermine Parliament's intention in intervening in what it considered to be an imbalance in the pub and tenant relationship. It is therefore important to take care that this imbalance should not carry over into arbitration, where delay to the resolution of disputes could undermine Parliament's intention and the ability for tenants to access the code rights. The code processes, including the MRO procedure, have set timescales designed to resolve disputes quickly. Extended stays, such as repeated and open-ended stays, may not be in the interest of both parties nor facilitate Parliament's intention, so they should be avoided. The arbitrator should have in mind the Regulation 32A1 duty on the parties to seek to agree a compliant tenancy through the MRO procedure. This includes ensuring that the POB openly concedes non-compliance if the proposal before the arbitration is known by the POB to contain non-compliant terms, so that negotiations are able to take place in a fair manner and costs in the case considered accordingly. For example, please refer to the PCA investigation into the Star Pubs and Bars use of stocking terms and the breach of the duty to continue to seek to agree a compliant MRO tenancy throughout the MRO procedure, and Star's failure to concede non-compliance in cases where it knew one or more terms had been found to be non-compliant and relies on those same arguments. However, the PCA would like to add that the MRO process is designed to enable the tenant to compare that option with their tied arrangements and decide for it what is best. The PCA states that delays in resolving arbitration undermines the ability to make that comparison, and that delay generally favours the POB over the tenant. So the PCA observes that MRO terms and rent cannot be backdated prior to the date of completion. The tenant who takes an MRO option may therefore be financially prejudiced by a delay in the MRO process if those MRO terms put them in a better financial position. For those new to PCA arbitrations, it is helpful, I think, to bring your attention to the fact that the POB may not be the immediate landlord of the tied pub in all cases. For example, the immediate landlord may be a subsidiary company, which is a group undertaking of the POB. Where the POB is the respondent, arbitrators should establish with the parties whether the immediate landlord is the POB, and where it is not, join the immediate landlord as a second respondent. For enforcement purposes, including regulatory steps by the PCA, it may be important for both the immediate landlord and the regulated body to be bound by one or by any order of the arbitrator. The PCA observes that in acceptance letter, the CIArb asked the POB whether there is an immediate landlord. And assuming the CIArb provides this information to the arbitrator, which in my experience it does, it is a simple matter of joining such as a second respondent. Turning to the arbitrator standards. On the 1st of April 2021, the PCA introduced standards for arbitrators appointed in pubs code arbitrations. These standards, which have been updated this month, are aimed at supporting the provision of quality and timely statutory arbitration services and facilitating the exercise of the PCA's statutory powers and duties in order to take effective action as the regulator. Adherence to these standards is intended to support the PCA in the appropriate exercise of her powers of appointment of an arbitrator. Clearly, these standards are not intended to otherwise affect the Public Code legal framework or the powers of the court. On accepting the PCA's appointment, the arbitrator is required to agree to the standards and to attend the Public Code training such as this, as the PCA may reasonably require. As part of the standards, the arbitrator will also be required to complete a closure form. The significance of this form cannot be overstated. This is to give the PCA clarity that the arbitration has concluded and to enable timely reporting of open and closed cases, case duration and outcome. It is therefore very important that the arbitrator completes this form accurately and provides it to the CIArb on behalf of the PCA once the proceedings have been terminated, and not, for example, delayed until the arbitrator has received payment of their fees. The PCA would like to emphasize this last point because it is where the PCA sees problems that impacts upon reports that the PCA publishes. If we could have the next slide, please, Katrina. And it's over to you, Bob.
Thank you, Nigel. It sounded like you needed a break anyway. One point that came up on the chat just now, which I'll comment on. Peter Colley mentioned that, does it mean that arbitrators should refuse a stay? No, if both parties actually agree a stay, you still should allow them to have the stay. It is the parties' process at the end of the day, but you should try and persuade them to not continually delay. Having said that, in one or two that I've had over the last couple of years, stays have gone on for a long time. It's very frustrating all round. But you do end up, at least I have ended up, with settlements at the end of those stays, so maybe not too bad.
Yeah, that's my experience as well. I've had a number where they've been stayed, normally actually, at the tenant's instigation, and only for then it to conclude in a negotiated settlement in the end of the arbitration.
Indeed. Okay, good. Thank you. So we're moving on to MRO and non-MRO disputes after Nigel has given his overview. Forgive me if my voice, I need to drink some water occasionally. I've just been abroad and come back with a cold naturally. Not COVID, I'm pleased to say. Right, so parts 5 to 8 of the code, that's regulations 23 to 40, include the provisions relating to MRO and the independent assessor procedure to go free of time. The time limit for making a referral for arbitration in relation to the MRO option depends on the nature of the dispute. For example, Part 5 of the Code, Regulation 23 to 27, concerns the MRO option, and Code Regulation 24 to 27 state the events upon which a TPT may give an MRO notice, and how long after a trigger event the TPT can send their analysis of the effect of such to the POB. It's 56 days. Now, although when we're running through these, I'm mentioning parts of the code regulations, don't worry, all of this is in the notes. You don't need to write it all down. But this is really to show you that the code does set out a framework and needs to be considered if you're looking at, and indeed if there has been a challenge to the jurisdiction based on the fact that the time limit may not have been kept. So therefore you need to check the facts and of course the code itself, and indeed what the trigger events might be. So the PCA say that some confuse trigger events with an MRO event. They are different. A trigger event is when there is an event causing a significant impact on trade. That's the trade of the pub, of course. The PCA have not seen MRO events in arbitration yet, but it is there. Most of the disputes that we have are MRO disputes with regards to the MRO lease being provided or suggested by the POB and the tenants not being terribly happy with it. So the significant increase in price, SIP, is a reason to be a trigger event. However, although there's a number of these, the most common are due to rent assessment and renewal of the lease. These can be trigger events. These are designed to be less frequent events. The common events, as I've said, are a rent review and a renewal. In relation to MRO disputes concerning post 1st of April 2022 tenancies, I say post 1st of April 2022 because there was a change to the regulations which came into effect on the 1st of April. And depending when the dispute arises, depends on which route you should take in dealing with these disputes and looking at the timetable that may or may not be applicable. Anyway, with disputes concerning post 1st of April 2022 tenancies, only the TPT can make a referral to arbitration, not the POB. The PCA says that to date, MRO full response referrals have only been made by the TPT, and it's more likely that a POB referral will arise in relation to the independent assessor's determination, in other words, the rent. The PCA has issued a statutory advice note outlining the PCA's expectations in relation to MRO compliant proposals. The advice note can be found on the PCA website, the details of which you will get later. So again, if you're having to look at what is the PCA's expectations in relation to MRO compliant proposals, this is a good place to start. The Regulatory Compliance Handbook is statutory advice under section 60 of the SBE Act, the Small Business and Enterprise Act, which sets out how the PCA expects a POB to behave to comply with aspects of the code. So again, this is quite important when you're dealing with any dispute. Chapter 4 on the MRO proposals makes clear the minimum steps the PCA expects a POB to take in satisfying itself that its proposed MRO terms meets the code tests on commonality and reasonableness. And it's the commonality and reasonableness of a proposed MRO lease which is important, because of course any MRO being proposed by the POB does need to be reasonable. The handbook also includes an MRO compliance record and declaration that the POB must complete for every MRO proposal. The POB's code compliance officer must sign this. Again, that's important. The chapter also includes advice on how the POB must serve and present the MRO proposal. It does not assume the offer of a new tenancy. This can be requested by the arbitrator if necessary. It's probably worth pointing out here that although most MRO proposals are in the form of a new lease, they can be in the form of an amended existing lease. They are not, that's not excluded, but it is, I would suggest, a little unusual. The PCO also observes that the statutory framework allows a brewing pub, so a pub-owning business that is also a brewer, to have a stocking requirement in an MRO tenancy. But again, this must be reasonable. The Department for Business, Energy and Industry Strategy has issued a clarification note on this, which includes that a stocking requirement can be included even if it's regarded as an uncommon term. So this is one example where a stocking requirement may be considered as an uncommon term in an MRO tenancy, but it is still acceptable. Of course, uncommon terms are normally considered as something that's unacceptable, but again, it depends on the facts and of course the submissions that are made to you. The POB is required to provide a compliant offer, and in demonstrating they consider the offer to be compliant, there's a checklist that includes having evidence to support their proposed terms are reasonable and common. Nigel has already mentioned this. This doesn't actually change the legal burden of proof, but it emphasises the duty on the POB to actually explain itself before, and hopefully before a dispute emerges. The PCA encourages arbitrators to look at this checklist when considering allegations of uncommon terms. In addition, there is advice about reasonableness. The terms must be common both individually and in combination. The PCA says that something that in combination is usual may well not be common, even if individually such terms are said to be usual. So you need to look at all of the terms, not just individual terms. It's the reasonableness of all of the terms taken together as opposed to any specific individual term, although of course a specific term may be so unreasonable as to make the MRO response as non-compliant. The regulatory compliance handbook can of course be found on the PCA website. The handbook deals with pub-owning business communications with the tenants, business development managers, training and operation, MRO communication and process. Could we have the next slide, please? Okay, you'll find an overview of the MRO process on the website, both pre-April 2022, the flow chart that's on the screen right now, and post 1st of April 2022. These can be quite handy in trying to work out if indeed either the tenant or the POB have acted correctly and within the time periods that are set down within the regulations. I won't actually take you through the flowchart, but as you can see, it's reasonably straightforward, giving the dates between, or times rather, periods between each step. So this is the pre-April 2022 procedure. And next slide, please. And we have the pre-April 2022 negotiating period flowchart. This gives an overview of the MRO negotiation period. Now, prior to the 1st of April 2022, the negotiation period was, I believe, 56 days. It's now, for any dispute, any matter after the 1st of April 2022, it's now a 3-month period. And the steps that one takes and how one deals with it are a little different as well. So again, it's worth looking at these flow charts and then checking with the regulations. So again, if we can have the next slide, please. And there we are, the post 1st of April 2022 procedure flowchart, which you see in comparison to the previous one is set out slightly differently, and the time periods and steps are a little different. So please make sure you look at these. Okay, so after the pub operating business, the pub has sent its full response. The parties enter into the negotiation period. All of this is on the flowchart, which is 56 days long. This, of course, is pre-April 2022. When the TPT tells the POB in writing it accepts the proposed tenancy. The TPT and POB must enter into that tenancy as soon as reasonably practicable. If they do not, either party may refer the matter to the PCA. The MRO procedure ends on the date when the tenancy is entered into. The TPT or POB must make the arbitration referral within 14 days if they dispute the terms, starting the day after the end of the 20-day period of response. Think about that. What does that really mean? The 14-day period does not start when the TPT receives the full response. The TPT must notify the POB in writing if the TPT intends to make an arbitration referral. Likewise, if the POB is making a referral, it must notify the TPT. Again, be careful about the timings and certainly when a referral can be made and when, of course, it's too late. Where the POB proposes another tenancy in the negotiation period, this is called a subsequent proposed tenancy. If you do not think the subsequent proposed tenancy is MRO compliant, you may make an arbitration referral within 14 days, starting the day after you receive the tenancy. The negotiation period and time for referring the MRO rent to an independent assessor does not start again when you receive a subsequent proposed tenancy. So again, if it's the rent that you're unhappy about, be careful of the timing. And as an arbitrator, you do need to be aware of this if this is in contention. Please note that a subsequent proposed tenancy is not a revised response. The arbitrator can decide the POB must provide you with a revised response following a referral. If the arbitrator decides there's been no failure in connection with the full response, the code treats the full response as having been received by you on the day of the arbitrator's decision. So again, when you've had the arbitration, you've provided your award, you've made your decision, you said there was no disputes that with regards to the MRO, that's an MRO event occurred, the 50-day, 6-day negotiation period starts again. So this is one section where you go back to the beginning, essentially. Where the arbitrator agrees with the POB's full response that there was no MRO event, the MRO procedure ends on the day of the arbitrator's decision. So if there was an MRO event, the 50-day negotiating position starts again. If there was no MRO event, your decision, your award ends it. The arbitrator can require the POB to send the TPT a revised response. For example, if they decide the proposed tenancy is not MRO compliant. The POB must provide its revised response within 21 days of the arbitrator's decision, or by another date the arbitrator decides. So there's some flexibility there. If the arbitrator decides the POB must send you a revised response, the 56-day negotiation period starts again, following receipt of the revised response. The procedure should only apply to cases already in arbitration. In relation to pre-1st of April 2022 MRO events, it has changed. And in fact, the majority that you will now receive will be, of course, post 1st of April 2022. Okay. So the flowchart that you have on the screen before you shows the procedure that you're likely to come up against in the foreseeable future. There may be one or two old arbitrations still ongoing that refer to the old procedure, but this is the one that you should mainly have to be dealing with. The difference between the pre and post 1st of April 2022 procedures in terms of the change from negotiation period to resolution period is identified within the regulations. Under the post 1st of April 2022 procedure, the 56-day negotiation period is replaced by the longer 3-month resolution period. Quite a big difference there. If the POB's full response is missing a requirement, the rent, for example, the TPT, or indeed the POB, has 14 days to make an arbitration referral to the PCA, starting the day after the TPT receives the full response. So importantly, it's when the TPT receives the full response. If the arbitrator decides that the full response was missing a requirement, the arbitrator can order the POB to send the TPT a compliant full response within 21 days, starting the day after the arbitrator's decision. So you make your award, the fully compliant response is now to be served within 21 days of your date of your award. It can, of course, be earlier. It's also important to note here, perhaps, that when you provide your award and you find that there's a missing requirement, that the MRO lease is not compliant, it's not for you as the arbitrator to actually tell the parties what the missing term is and tell them to amend accordingly. All you can actually decide is that it was not compliant. Okay, so if there was no failure with the full response, you're treated as having received the full response on the day of the arbitrator's decision. That's the parties. Where the POB has agreed there was an MRO event, the resolution period starts the day after the arbitrator's decision. After the POB has sent the TPT its full response, the parties enter into a period of negotiation called the resolution period in the code. This period is the beginning, it begins on the day after a POB provides a full response to enable the TPT and POB to negotiate the MRO offer. The resolution period is 3 months, as we've already said. TPT can end it earlier by giving 7 days notice to the POB, but it cannot be any shorter than 21 days. So 7 days notice can be given, but not until 21 days has elapsed. The updated period of response is defined the updated period of response is within the code, and it's defined as a 7-day period at the end of the resolution period, during which the POB may provide an updated full response. As you read the code, you will recognize, as in so many documents or acts, that the wording can be a little difficult, and you may have to read it a few times to find or understand fully what is required. This is optional, but the TPT must allow the 7-day period to provide. This is stated a few times. If the TPT gave the POB notice to end the resolution period, the updated period of response will start after the TPT's 7-day notice period has elapsed. As you'll recognise, whilst the resolution period is set for a set amount of time, the code requires that the TPT and the POB should try to agree an MRO compliant tenancy and rent throughout the MRO procedure. If you agree a tenancy, that's fine. If the arbitration has not run its full course, maybe it's been delayed and postponed a number of times, you as the arbitrator would then be expected to write an award highlighting that settlement has occurred. Not necessarily the terms of the settlement, but you will be required to write an award showing that settlement has occurred, or indeed the referral has been withdrawn, and you should also deal with any costs issue. If the TPT tells the POB in writing that the TPT accepts a proposed tenancy, the TPT and the POB must enter into the tenancy as soon as reasonably practicable If the TPT does not, either party may, if it doesn't accept it, either party may refer the matter to arbitration. The MRO procedure ends on the date the parties enter into the tenancy. So where does this leave us? If an arbitration referral is made in relation to the MRO full response, the arbitrator can order the POB to provide the TPT with a revised response under Regulation 33 of the Code. In an appeal on this point, the High Court decided that the Pumps Code statutory framework does not give an arbitrator who finds an MRO proposal to be non-compliant the power to alter the POB into including specific terms in its revised response, the point I made a little earlier. So what can you do? The arbitrator can identify that an offer is unreasonable because it does not contain a particular term, must be, and for example, has to specify tenancy length, and the length has to be reasonable. They cannot order a particular term must be included in a proposed MRO tenancy. So, for example, they can't say if they can see that it's unreasonable because the term that's been provided may be too short, but they can't then actually say what that length of the tenancy should be. The High Court judgment worth looking at in this regard is Punch Partnership and the Highwoman Hotel in 2020. These are on the PCA website, by the way. And the PCA's online publication, Judgments in Arbitration Appeals and Publication of Arbitration Awards, as published on the 4th of April 2022, that particular judgment is also referred to there. In the Highwoman case, it was found that the duration of the MRO tenancy that a pub must offer to a TPT must be reasonable in the circumstances, and it's not automatically reasonable just because it is the same length as the remaining term of the existing tied tenancy. This is, of course, where a tied tenancy has some years to go. Provision is made for the re-referral of a revised MRO proposal. So you can re-refer any revised MRO proposal to arbitration. I'll just briefly mention that under the pre-1st of April 2022 procedure, where the arbitrator orders the POB to provide a revised response, the arbitrator must include provision for the TPT to refer any dispute over the compliance of the revised response to the arbitrator in the present arbitration, or the PCA has a separate referral. It can't be assumed that this would be the case. However, post 1st of April 2022, the changes to the code provide that the TPT has 21 days from the date after the TPT receives a revised response to make another arbitration referral to a PCA. If you do not consider it MRO compliant, the TPT does not consider it to be MRO compliant, or make a referral to the independent assessor because you're not happy with the rent, or maybe their rent has not actually been agreed. Again, there's no review of this on the PCA site. So hopefully that wasn't too confusing. So what happens, as happens quite a lot actually, where there's a settlement or withdrawal of the referral. As already mentioned, where an arbitrator orders a POB to provide a revised response, the code specifies that this will start the negotiation period again. The right to refer the MRO rents to the independent assessor and the timescale for doing so arises from the negotiation period. Where an arbitration dispute is settled or withdrawn, the pub's code framework does not provide an automatic route back to the MRO process. Be aware of this. It's not within the gift of the parties to reset the statutory MRO process in these circumstances, but they can agree what they will ask the arbitrator to provide as part of his award. So as an arbitrator, you need to be aware of this. The PCA would like to emphasise that this applies to both pre and post 1st of April 2022 arbitrations. A lot of consent awards have no provision to refer to the independent assessor, and the TPT is therefore unsure what the timescales they are working to. So where you have a settlement, but it's clear the rent is not part of that settlement, just the terms of the lease excluding the rent, or where it's the TPT is not in agreement with the rent, you need to set out in the award where they are in the process and the timescale that they have to make an application to the independent assessor to consider the rent. Obviously, any settlement must be agreed in writing, including email. And it has to be by both parties to the arbitrator before the arbitrator can accept that a settlement has occurred. You can't only have one side saying there's been a settlement. It should include the costs award. If a referrer is withdrawn, an award should still be made, noting the matter has been withdrawn and also dealing with costs. Costs will be dealt with a little later. Where the parties reach a settlement on MRO terms but wish to refer the MRO rent to an independent assessor, pursuant to Regulation 30.3 of the Code, and only the TPT may do so, the arbitrator should make it clear where the parties are on a statutory timetable. In other words, making clear how many, it's a 21-day period, I believe, but they need to check, make sure that the award sets out the time that the TPT has in order to make such an application. We don't only deal with with MRO disputes, of course. There are non-MRO disputes. I currently have one that's dealing with essentially with dilapidations. So although they are relatively rare, they do occur. Section 49 of the Small Business and Enterprise Act sets out the time limits for doing so. It's to be noted that a POB cannot make a non-MRO referral. There is statutory advice, which was published in the 2nd of August 2021 on timescales for referrals. The PCA, it's on the PCA site again. It's the PCA's view, and be careful here, it's the PCA's view, this isn't necessarily the view of a court should it ever come to it. The PCA's view is that a TPT has 4 months and 21 days from when the dispute arises to refer the non-MRO dispute to the PCA for arbitration. You have to look at the facts. When did this dispute arise? And again, look at the code to make sure that you agree or not that it is in fact 4 months and 21 days. But that is certainly the PCA's view. The TPT may refer a dispute for arbitration if it relates to the allegation that a POB has failed to comply with the POB's code itself. There are strict deadlines connected with the rights under the POB's code for making arbitral referrals, and again, these are quite important. It's not unusual for the POB to actually raise the points that the TPT is out of time, or indeed referred it too early. So before a referral can be made to the PCA, the TPT must notify the POB that they think the POB has breached the POB code. The notice is important because the POB is expected to try and resolve the issue, obviously prior to going to arbitration. The parties should do all they can to remove the need for the dispute to be referred to arbitration. If the dispute has not been resolved after 21 days, from the TPT giving notice to the POB, then the TPT may make an arbitral referral. So they can't make a referral earlier than the passing of 21 days. In all cases, the TPT may not refer a dispute for more than 4 months after the first date when the dispute could have been referred. So again, that's something that could cause some argument. Again, it's the PCA's view that the first date when a dispute could have been referred would be 21 days after the dispute arose. The question there is, when did this dispute arise, I guess? This is because notice of the dispute could not have been provided to the POB on the same day that the dispute arose. That's possibly an arguable point. The deadline for referring the dispute is therefore, in the view of the PCA, 4 months plus 21 days after the dispute arose. I'm sure somebody will argue at some point that the notice of dispute could have been provided to the POB on the same day that the dispute arose. I haven't seen that one yet, but I guess that will be argued at some point. If an independent assessor has been appointed and fails to make a determination of the rent, or the TPT or the POB considers that the rent determined is not the market rent, then either the TPT or POB may make a referral to arbitration within 14 days of the date when the determination should have been provided. So if the determination hasn't been provided, 14 days from when it should have been provided, or when it has been provided and they disagree, it will be 14 days from when that determination was made. If the independent assessor's determination is referred to arbitration and is found to have failed, the code enables the arbitrator to substitute the independent assessor's figure with the arbitrator's own determination and explain why, or directs the independent assessor to make a second determination, or further order another independent assessor to be appointed. So you've got some variation there on what you can do. Where an arbitrator orders an independent assessor to make a second determination, or directs another independent assessor to make a determination, that determination has to be made within 21 days. Where the agreement and/or tenancy has an arbitration agreement within it, and where the dispute is not a matter covered by the Code or the Small Business and Enterprise Act, in relation to pubs, of course, the POB cannot make a reference to arbitration in relation to non-MRO disputes in respect of this process. You will find that some leases are covered by the Landlord and Tenant Act 1954, and a protected tenancy under the Landlord and Tenant Act 1954 can be subject to an MRO request by the TPT. But they can only do this at the date when the protected tenancy can be renewed in accordance with the Act, the 1954 Act. When a POB intends to renew a tenancy under the 1954 Act, it must provide a rent proposal if requested, identify publicly available reports showing tenancy costs for Thai pubs in the UK, along with relevant data for comparison of the performance of the Thai pub, and provide copies of those reports, or show the TPT where to obtain those reports, so that they can consider whether the proposed rent is reasonable or not. This is a duty upon the POB. Okay, I think I've exhausted my section for the time being. Over to you, Nigel.
Thank you, Bob. There is just one question that is in the chat box, and that's from Matthew Martin, and he was asking whether the timings are of the essence.
Essentially, yes. If you don't comply with the timings, it's a bit like adjudication. They are mandatory. You will be out of time.
Katrina, could we have slide 13, please? And next slide. Okay. So turning now to the treatment of costs, it is important that the pub code arbitrations represent value for money, irrespective of the paying party. The PCA therefore wishes to gather hourly rate information to better understand the range of hourly rates of recommended arbitrators. This information also supports the PCA in ensuring the reasonable exercise of her appointment powers. The arbitrator's hourly rate therefore forms part of the information the arbitrator provides to the CIArb, which in turn is provided to the PCA, when agreeing to a recommendation for appointment in each case. Understandably, the PCA requires certainty about when an arbitration has closed for public reporting and monitoring purposes. Naturally, a case is not closed until the arbitrator has dealt with all cost matters, including arbitrator fees and expenses, party costs, and any PCA costs as the arbitrator, to show that the statutory arbitration process has completed. The PCA has advised, however, that since there are generally no cases where the PCA has acted as an arbitrator, the PCA arbitrator costs are no longer an issue that requires consideration. Upon the rare occasion where such cost has been incurred, the PCA says that such can be explained on an individual case basis as necessary. In relation to arbitrator costs, Regulation 3.3 of the fees regulations for MRO disputes, including independent assessors, and Section 51.6 of the ESB Act for non-MRO disputes, requires the POB to pay the arbitrators reasonable fees and expenses, except where the tenant makes the referral and the arbitrator concludes the referral or notice was vexatious. Once the arbitrator is satisfied the test has been met, they should consider whether to exercise discretion to make such an order, and if so, the amount of that order. PCA has recently published a new fact sheet on arbitrations and costs, which will be useful reading material for arbitrators. It has some worked examples on costs, which could be used in the training. And I've provided a link in the written materials to be made available to you in today's seminar. Now, turning to party costs, Regulation 3.5 of the fees regulations for MRO disputes and Regulation 4.4 for non-MRO disputes caps the tenant's exposure to the POB's costs at £2,000. This is unless the tenant's referral was vexatious or their conduct in connection with the arbitration resulted in an unreasonable increase in the cost of the arbitration. This alternative creates an additional basis upon which a tenant can become liable for the POB's costs that do not exist in relation to the arbitrator's costs. In either case, the arbitrator can order the tenant to pay anything up to the POB's full cost of the arbitration. The tenant's exposure to costs may, however, serve as a deterrent. There will often be an imbalance in the resources of a large POB and a tenant. While the statutory framework allows for circumstances in which a tenant can be liable for cost, it is nevertheless important that tenants are not deterred from reasonably pursuing their arbitration rights. PCA considers it important for tenants to have an opportunity to comment where the arbitrator is minded to order that the tenant pay arbitrator and/or party costs in line with the fees regulations. Where the tenant may be liable for the POB's full costs or a proportion of those costs, the PCA considers the tenant should have an opportunity to comment on the reasonableness in respect of whether the test has been met and how the arbitrator's discretion should be exercised, as well as in respect of the amount including whether the costs have been recently incurred. In terms of deposits and interim payments, arbitrators should consider whether raising an interim invoice or requesting a deposit which is payable by the tenant in full or in part are consistent with the statutory framework, which provides that the arbitrator's reasonable fees and expenses are to be borne by the POB unless the arbitrator concludes the tenant's referral is vexatious. The making of a cost award is a separate matter from that of interim invoicing, and clearly the two should therefore not be conflated. Since the fee regulations, in particular Regulation 3, do not prohibit the rendering of an interim invoice or invoices, or even refer to such, nor for that matter does the Arbitration Act 1996, arbitrators are entitled to raise such particularly where extensive stays have been or are sought in order to facilitate the parties' negotiations. Although serious consideration ought to be given to raising such with the POB as opposed to the tenant, save where the tenant's referral is vexatious. But as I've already mentioned, it's very difficult to assess whether a tenant's referral is vexatious, particularly where the arbitration is still in its early stages. If we could have the next slide, Katrina. And over to you, Bob.
Unmute myself, always a good idea. This may be a good time for everyone to have a bit of a break, actually, where...
Indeed.
Yeah.
So shall we return at 4 o'clock?
Do you want a half-hour break or just keep it to 15 minutes?
It's fine with me. Provide some more time for questions at the end.
Mm-hmm. Does anyone require a half-hour break, or is 15 minutes sufficient?
Not for 15 minutes.
Yeah, okay.
Okay, 15 then.
Seems to have agreed for 15, that makes sense. Time to put the kettle on and make a cup of tea.
Okay, thank you.
Right, see you in 15 minutes, gentlemen, ladies, thank you. Okay, thank you, gentlemen, ladies, coming back. We're now moving on to PCA advice, guidance, and High Court judgments. So this is really information that the PCA requires, how they deal with awards and disseminating information. The Small Business and Enterprise Act under Section 52 and Regulation 61 of the Pubs Code gives the PCA statutory powers to request information from an appointed arbitrator or from the parties to assist the PCA in carrying out their functions. Part of this is publication of awards. The PCA encourages openness and transparency in the operation of the Pubs Code and publishes awards and analysed summaries of on the PCA website in the public interest. This is also useful, of course, to arbitrators because they can look at previous awards that may or may not be similar, but dealing with similar issues, to see how matters have been dealt with. Of course, there is no precedent. After all, they are arbitral awards, but they can give you pointers as to perhaps a way to deal with certain issues. They're also published, of course, by the PCA to allow the POBs and the TPTs to have an understanding of the likely way in which disputes may be determined and how perhaps the process works. So awards will be considered for publication by the PCA, where the award contains an arbitrator's decision on the issues in the dispute. Not all awards are published. At the moment, they don't publish awards about an independent assessor's determination. So we're normally talking about MRO disputes, or indeed non-MRO disputes, but not the rent determination itself. When the PCA considers that publication is appropriate, having obviously received and read the award, the PCA, through its advisors, will contact the parties in each case to let them know that these awards are going to be published. The parties themselves will have already given permission by way of the process of the referral and entry into the arbitration for the published awards to be published. They are redacted, of course, quite rightly so the parties are not identified, or indeed the pub identified. All of these published awards and summaries can be found on the PCA website. So that shouldn't be too difficult. And there are quite a few of them. And it's not necessarily that easy or quick to find something that's appropriate, but sometimes it's worth spending time looking through the published awards to see if there's something that can assist, especially where you think you have a tricky issue to deal with. However, the PCA doesn't expect you to be aware of previously published awards. There's a publisher's note which explains they're not binding and that an arbitrator is not bound for them implying the law. So they are really just for information. As an arbitrator, you may wish to make it clear in your terms and conditions or your directions that they are not required to be aware of published arbitration awards as a matter of course, in that you are not aware of them, and that it would be for the parties to identify any published awards on which they seek to rely. Of course, this will be normal. The POBs themselves tend to be represented by solicitors, where unfortunately TPTs can either be representing themselves or they may be using non-lawyers to represent them. And so where you as the arbitrator are trying to ensure there's an even playing field, you've got to be careful not to be making the TPT's case for them by providing too much in the way of guidance, but you can give them some guidance in respect of what they should be doing. However, the PCA does advise that arbitrators should be aware of the information on the website, take into account the statutory guidance, we've been obviously referring to that today, and that you may wish to consider previous awards. Ultimately, the PCA is looking for a set of awards that, yes, of course, they're not binding in any way, but provide a set of awards that allows arbitrators to be relatively uniform, depending on the facts, of course, in the way that they consider the facts and apply the law. There are advice notes published by the PCA. There's one, for example, in referral to the market rent only MRO proposals, and these may be worth looking at as well. Further information is, of course, available on the PCA website, and that information includes fact sheets on the pubs code, published awards and summaries of pubs code arbitrations, statutory advice, and High Court judgments on pub code arbitration appeals. And those actually are the ones that you really should be aware of. It's also suggested, and indeed I found useful, for you to sign up for email alerts on the PCA website, which notifies you of updates and new publications. You'll also find the PCA on Twitter, Facebook, and LinkedIn. But definitely I would encourage, and I'm sure the PCA would as well, for you to sign up to their email alerts, because they are useful and provide up-to-date information on anything that's just changed, or indeed judgments that may be important. So as far as finding further information is concerned, your first point of call would be the PCA website, which is quite in-depth, and as I said, has the various fact sheets that are very useful to you, and indeed very useful and aimed at the TPTs and the pub owning businesses. So on that note, I shall hand over to Nigel to deal with the worked examples and case studies.
Thank you, Bob. There is a question in from Graham Chase, and he asks, if the parties have not referred to a particular award, how can an arbitrator justify trawling through all the published awards? Even if you find a precedent, it is highly dangerous to consider that without remitting the position back to the parties. I think that's the crux of his point.
Yeah, I think so, yeah. You wouldn't be going trawling through all the awards unless you come across a point that you haven't dealt with before, you'd like to see how other people have dealt with it. It's really for information only. I wouldn't suggest that you point to any previous arbitral award as some sort of precedent, because they do not have precedents. If the parties refer you to previous awards, by all means you can refer to them, because of course they're part of the submissions. If they're not part of the submissions, you can use it for your background information. If you really think you should be relying on, and I suggest you don't actually, but if you really think you should rely on a previous award, you of course must put that to the parties for their comment.
Thank you. So Katrina, please may we have the next slide? 16. No, 15, that's it. Thank you. Copies of examples of awards can be obtained by visiting the PCA website, as Bob said, and a link for which has been included within the written materials to be made available to you after today's seminar. The following is an example of a scenario award contained within the PCA website, which we would like to bring to your attention, not only in terms of its content, but also to emphasize the materials that are available to you online. The background to this scenario begins in this instance with the tenant who first made a referral to arbitration against the pub on two grounds. First, in relation to the pub's refusal to supply a rent assessment proposal, and secondly, in relation to the agreement on gaming machines operated by the pub being a tie and unlawful. The first arbitration was settled by way of a deed of variation, which dealt with the first ground only and said nothing about the second ground on gaming machines. The tenant then made a second referral in relation to the gaming machine agreement. However, the pub claimed that the arbitrator did not have jurisdiction to consider the second referral on the basis that the pub asserted that the deed of variation settled the first arbitration, and that since the game machine agreement had been previously arbitrated under the first arbitration, it could not now be re-arbitrated. The POB also claimed that the second arbitration referral was invalid due to having been made to the PCA 2 days too early and was therefore time barred. The tenant denied that the gaming machines dispute could not be arbitrated or that it was invalid or out of time. Section 49(2) of the SB Act provides that a tenant can only refer a dispute after the expiry of the period of 21 days, beginning with the date on which the tenant notifies the POB of the alleged non-compliance. Section 49 also prohibits disputes being referred to arbitration more than 4 months after the date the dispute could have been referred. Turning to the jurisdictional issues in slightly more detail, the POB argued that the arbitrator did not have jurisdiction to consider the gaming machine dispute for the following procedural reasons. The deed of variation settled the first arbitration, including issues raised about the gaming machine agreement. Since the current dispute about the gaming machine agreement had been previously arbitrated, it could not be re-arbitrated. The arbitration referral about the gaming machine was time barred, and the referral of the current dispute about the gaming machine was made before the expiry of 21 days and therefore was invalid. The TPT rejected the POB's arguments, stating that the pubs code arbitration should be low cost and simple, avoiding technical legal arguments or processes. Second, the deed of variation in the first arbitration did not settle the gaming machine dispute, which was the subject of the second arbitration referral. The current dispute about the gaming machine agreement can be referred to arbitration as it is a recurring dispute. And fourth, the tenant cannot sign themselves out of the pubs code and so cannot enter into an agreement with a pub which would allow the pub to bypass the pubs code. So, had the dispute regarding the game machines been previously dealt with? The arbitrator held that the confidentiality of the first arbitration did not prevent reference to relevant issues from the first arbitration being disclosed in the second arbitration. The matters in the first arbitration were irrelevant to the present arbitration and so could be disclosed. The arbitrator then went on to consider if the matters referred to in the first arbitration could be referred again for arbitration. The arbitrator also considered the case of Little versus Just Fitness Limited, which is a 2010 case. In Little, the dispute similarly had 2 limbs, but the parties had only arbitrated one and had failed to agree to hold over the second limb to a future date. It was also the case that in Little, the court had found that both limbs had been in fact referred to arbitration, and the arbitrator had incorrectly concluded only one limb had been referred. Accordingly, the court held in that case that the parties could not arbitrate the second limb at a later date. However, the arbitrator in this case held that Little was not directly applicable because the first arbitration had been settled by agreement and the referral withdrawn, and no arbitration award had been made as a consequence. The arbitrator held that the deed of variation entered into between the parties did not have to have the effect of preventing the tenant from making a second referral to arbitration on the gaming machine agreement, despite the overlap between the issues in the 2 referrals. What are the timing? Well, in terms of the timing issue, the POB argued that since the first arbitration had been settled in 2019, the current dispute about the gaming machine agreement had been made in 2020, and therefore the 4-month time limit under Section 49 of the 2015 Act had been exceeded. The tenant argued that the referral was in time because the breach was recurring. The arbitrator concluded that a recurring breach was a series of distinct breaches rather than the continuing effects of the occurrence of a specific breach. The arbitrator also found that the alleged breach had crystallized when the deed of variation was entered into, and what happened since was simply a consequence of that breach. The arbitrator therefore held that the referral was made late, and so the referral was time barred under section 49(4) of the SB Act 2015. What about the findings of, what were the arbitrator's findings on whether it was too early? Well, in relation to the POB's argument that the reference was premature and therefore invalid, the arbitrator found that whilst the referral to the PCA was made 2 days earlier than the prescribed 21 days required by section 49 of the SB Act, since the PCA did not take any steps to accept the referral until the 21 days had elapsed, the dispute had not been referred early. Katrina, could we please have slide 16? And I'll pass over to Bob.
Okay, thank you. Termination award by consent. And here on the slide, as you can see, is an example of the wording that could be used where you have a termination award by consent. So the wording used here is upon the parties having entered into an agreement for the surrender of the claimant's lease of the premises, and upon the claimant agreeing the full terms, the terms of the full response are MRO compliant within the meaning of Regulation 29 of that code. By consent, it is ordered that the arbitration is terminated. The respondent shall pay the reasonable fees and expenses incurred by the arbitrator, and there be no order as to party costs. Next slide, please. The reasons given, the termination of the arbitration. The arbitrator finds that the parties agree that no failure has occurred in connection with the MRO for response. The arbitration has therefore been terminated in accordance with Article 36(1) of the CIArb rules, which provides: 1. If before the award is made, the parties agree on settlement of their dispute, the arbitral tribunal shall either issue an order for the termination of the arbitral proceedings, or, if requested by the parties and accepted by the arbitral tribunal, record the settlement in the form of arbitral award on agreed terms. Okay. And the next slide, please. And then the suggestion of the cost award section of the award. Under Regulation 3.3 of the POB pays save where the tenant made the referral or gave the notice, and the adjudicator or the person appointed by the adjudicator under Regulation 58.2 and 60 of the Code concludes the referral was vexatious. The regulation applied in relation to an MRO disputes applies. The award for costs is therefore that laid down by Regulation 3.3 of the Code. It is commonly the case that parties agree to bear their own costs, and so no order as to parties' costs is normally made. So what we have here is suggestions of what you should be looking for in your consent award, or where the referral has been withdrawn. You don't need to set out all the regulations, but these are the aspects that you need to be aware of, and make sure that you are applying those within your award. You can use this wording as is being suggested here on these slides. And of course, you would sign the award in the normal way with your signature, the date of the award, and the references applied by the parties, if any. As an alternative to this, you can have a termination award in the form of an order, which records the procedural background, the reaching of an agreement by consent, as attached to the order, as signed and dated by the parties, and a record that by consent it is ordered that the arbitration is terminated. Termination by consent, of course, will be tailored to suit the circumstances of that termination. My personal view is where you have a settlement, you would write your award, setting out the procedure, setting out the steps that are taken, any periods where the parties have agreed to extend time or to essentially to stay proceedings, so that you have a full list of, best way to put it, yes, actually really just a real full chronology of what has happened, so that should there be an issue, anyone looking at the award can see what has happened. With regards to the costs, yes, the parties tend to bear their own costs. You would normally have this agreed by the parties before you write your award. You would, of course, set out the arbitral cost, your costs as the arbitrator, which would normally be paid by the POB. And if there is an issue to be dealt with on costs, you would deal with that. However, if it's a settlement, there normally wouldn't be an issue on costs, at least the party costs. If the TPT has withdrawn the referral, there may be an issue on costs, because the POB may say, of course, that the TPT has acted unreasonably in some way. So there may be something to deal with there. But essentially, where a matter is settled or withdrawn, you should be writing your award, setting out the settlement, and then dealing with the costs. One other aspect that I mentioned a little earlier, if necessary, you should also deal with any time limits there are for the TPT to issue or start a matter before the independent assessor, because that's not necessarily automatically going to be the case. Next slide, please. Back to you, Nigel.
Thank you very much. So, considerations specific to the Public Code statutory arbitrations. In terms of consideration specific to PCA statutory arbitrations, the PCA encourages openness and transparency in the operation of the code. Publication of awards made in the Public Code arbitrations, or summary of those awards, enables the industry to better understand previous decisions and consider how the Pubs Code is being applied in individual cases. However, neither the PCA nor an arbitrator is bound to follow published awards in applying the law, as Bob has already previously explained. But such awards can be used to support the industry's consideration of the proper interpretation of the Pubs Code. The outcome of an arbitration is based on its facts and the evidence produced in the case. It is not binding in other cases where the landlord and tenant are not the same. Nevertheless, the PCA does expect a regulated POB to consider its understanding of the law in light of each award that makes a finding on the interpretation of the statutory framework and to adjust its behaviour towards tenants as appropriate. That said, the publication of an arbitration award or an award summary does not mean the PCA endorses the decision, and it does not form legal advice about any issue. Turning to arbitrator liens, Section 56(1) of the Arbitration Act states the tribunal may refuse to deliver an award to the parties except upon full payment of the fees and expenses of the arbitrators. In accordance with Regulation 3.3 of the fees regulations, the POB is required to pay the arbitrators reasonable fees and expenses, except where the tenant makes the referral and the arbitrator concludes that the referral was vexatious. Under Arbitration Act Section 56, an arbitrator may refuse to deliver an award to the parties except upon full payment of the fees and expenses of the arbitrator. Section 94(2)(a) states that the provisions of Part 1, which includes Section 56, do not apply to statutory arbitration if, or to the extent that, their application is inconsistent with the provisions of the enactment concerned. The PCA's view is that Section 56 of the Arbitration Act does not apply to pub code arbitrations. This is because it is considered to be inconsistent with the statutory framework and therefore not applicable to the statutory arbitration. Regulation 3.3 of the fees regulations provides that the statutory requirement of the POB and the route through which the payment of fees can be enforced. Further, any delay in issuing the award could be detrimental to the tenant. For example, it may hinder their ability to continue the MRO or non-MRO process. Such delay must not create an incentive for the POB to avoid prompt payment of the arbitrator's reasonable fees and expenses, which may undermine and frustrate the process of the POB's code. So considering all this, the PCA's view is that Section 56 of the Arbitration Act does not apply to pub code arbitrations on the basis that it is inconsistent with the statutory framework. Further, the PCA as regulator would want to know if a regulated POB did not comply with the cost award. So you may report any matters in terms of your fees and the lack of payment to them. The PCA and the CIArb, in terms of its dispute avoidance service, DAS, consider that they are each a controller of personal data they hold in connection with each case, and that arbitrators will also become a joint controller of personal data for the purposes of the Data Protection Act 2018 and the UK General Data Protection Regulation, GDPR, that they hold. The PCA considers that the transfer of personal data to arbitrators in relation to an arbitration is for a lawful purpose in the carrying out of its public task to arbitrate pub code disputes. Arbitrators are reminded of their obligations to keep the personal data, in their case, confidential and not distribute or process it in any more widely than is required to comply with their role as arbitrator. Arbitrators are also reminded of the need to keep the parties' commercially sensitive information confidential. In relation to previous CIArb dispute appointment service correspondence that an arbitrator may find helpful to be given, requests for previous correspondence or documents should be directed to the parties, and it is for the parties to assist as required. By virtue of Section 52 of the SB Act and Regulation 61 of the Code, the PCA also has powers to seek information from the parties and any other appointed arbitrator to assist the PCA in carrying out their functions. Arbitrators should also be aware that any information they provide to the CIArb or the PCA in the course of their appointment may be forwarded to the PCA to assist the PCA in carrying out their functions. Upon appointment, the DAS, on behalf of the PCA, requests that arbitrators email copies of any of the following to the dispute appointment service as soon as possible: further directions or orders made, pleadings received, and awards made. The PCA would like for it to be strenuously emphasized that awards should be sent to the CIArb at the same time they are issued. This is because the information is used for reporting and there are performance measures generated on the basis of the timeliness of the publishing of the award. It is stressed that documents should be sent to the CIArb at the time they are issued or received, as again, this is a quite common problem where they have to be chased up, which creates an administrative burden. However, the CIArb or the PCA should not otherwise be routinely copied into correspondence between the arbitrator and the parties. The PCA may seek further information from an arbitrator, if appropriate, to assist with the carrying out of their functions. Should the parties settle the dispute or withdraw the arbitration referral, arbitrators are required to notify the CIArb of the updated case status as soon as possible, so that it may be possible to update the records. Further, the PCA needs to be notified of any application to challenge or appeal an award to allow for any regulatory considerations, including in respect of publication. The PCA welcomes an early indication of any intention to make an application in respect of a challenge or appeal. Should this occur, arbitrators are requested to notify the CIArb on behalf of the PCA, and the PCA may request further information as appropriate. The CIArb also respectfully requests arbitrators to provide monthly updates in the case by the 25th day of each calendar month via email pca@ciarb.org. A brief form format is sufficient. In the event no activity is taking place, and also still would require an update to be given to that effect. Next slide, please, Katrina. I think that is over to you, Bob.
Indeed, thank you. Just replying to a question put by Graham. He was talking about arbitral awards that are published. Yes, they are, of course, anonymized, and arbitrators relying on them. Well, I'm not sure I actually said that you should rely on them. You should be aware of them, certainly. But if you are going to make a decision, it has to be your own decision based on the facts and the law as you see it. What you should not be doing is simply following somebody else's arbitral award. Now, the PCA does want consistency, that's certainly true, but you have to bear in mind the award is your award, it's not somebody else's, and it has to be made in the correct way. If you have an arbitral award that's been published that you believe is helpful in making your decision, and the parties in their submissions haven't made any reference to that award, or indeed the issues within that award, safety first. You should put that to the parties if it's going to affect your decision at all. You shouldn't blindly follow something without putting it to the parties. I hope that clarifies the point. Okay. So, the arbitrator standards. On the 1st of April 2021, the PCA standards and the PCA performance measures were published. Now, these standards are to be followed by the PCA arbitrators, and certainly you should be aware of them and should have read them. What do they try to do? Well, the standards are there to promote timeliness, quality, and consistency. Arbitrators are required to agree to adhere to standards when taking on any new appointment. This is part of your duty. Within the standards, there's a requirement for the PCA and the Chartered Institute to aim for an appointment of an arbitrator within 25 working days from acceptance of a case. Therefore, when the Chartered Institute makes contact with you concerning a potential appointment, a quick response by an arbitrator is going to be greatly appreciated, of course. And indeed, if you are approached, you should indicate quickly if you can undertake the matter. For your own good, for the party's good, but also for good administration. The PCA has performance measures in a number of areas. And one of those is the timings and speed with which appointments are made. They also are looking at the time period taken for awards to be published, which is one of the reasons why they suggest, they can't insist, but they suggest that the whole process should be undertaken reasonably quickly. As already mentioned, of course, whereas stays are not something that should be encouraged, at least numerous stays should not be encouraged, stays are a matter for the parties. If both parties agree to a stay, you as the arbitrator should respect that. You should also try and persuade them to get a move on. One of the reasons, of course, being that any delay is likely to hurt the TPT and less likely to hurt the POB. What else do the codes standards expect? They expect expectations of how the arbitrator will communicate with the parties. The expectation of reporting case progression and timescales. In fact, they do hope that you, or in fact expect you, to report back to the Chartered Institute on a regular basis as to the progression of any case. The PCA uses their powers as regulator to ask for this information about the arbitration, and they are using this information to ensure standards are kept. They will also be using the information to see if there needs to be any change to those standards, and in particular, the timescales. As already mentioned, the conduct of the arbitration is a matter for the appointed arbitrator and will depend on the circumstances, including the complexity of the issues and the approach of the parties. But what's really expected? The arbitrator is expected to contact the parties within 5 working days of appointment to confirm the arbitrator's terms and conditions. The arbitrator must also seek to establish if there's a second respondent to be added to the group company of the pub-owning business. This is something you'll see quite often, where the pub-owning business is not necessarily the only respondent. There may be a secondary business that is involved. And so therefore you need to make sure that if there's a secondary respondent, a second respondent, that they are included in the arbitration. This is to make sure that the regulated entity is included regardless of legal arrangements in the group undertaking. So you may have part of the group that owns the pubs, and there's another part of the group which runs a different part of the pub owning business, but is actually the regulated part. Again, it depends on the pub owning business. Normally, you'll find that both are included as a responding party. With parties' consent, the arbitrator may order a stay of proceedings at the outset before it even gets going. The timescale stated in the paragraph immediately above will start from the expiry of the period of the stay. So the establishment of your agreement of your terms, the 5 days, if there's an instant stay, will not stay until the stay, will not start until the stay has ended. You'll note that there are no standard directions that are specific to pub codes arbitrations. The duration, of course, depends on the circumstance, but in most cases, they are to be determined on the documents. There aren't that many that require a physical hearing or an online hearing. Sometimes you expect expert evidence, it's necessary, but not on all issues. So the timescales will vary depending on the complexity and what's required. The timescales that are looked at are intended to have an issue of a substantive award on the disputed issues within 6 months. So that's basically what you're aiming for, from appointment to your award within 6 months, and the case closure within a month thereafter. The case closure can be after the substantive award if there's then going to be a separate cost award. You have to, of course, fill out the case closure forms and send those to the Chartered Institute. So the 6 months would normally start from the exchange of party statements of the case, including any replies. Oh, sorry, not starting with it. You would expect the party statements, case statement of case, statement of defence, any reply within 3 months of the start of the arbitration. The remainder of the case management steps by the parties, provision of documents, witness statements, etc., if they're not part of the statement of case, would be normally expected to be 1 month after the close of pleadings, with the issue of an award 2 months thereafter. These are just suggestions by the PCA. They would like you to comply with these if at all possible. And the whole idea is to get the matter dealt with effectively and quickly, certainly quickly in arbitral standards. Again, it's not always possible, of course, depending on the nature of disputes and depending on the submissions of the parties in respect of the timetable. But this is what any arbitrator, a PCA arbitrator, should be aiming for. What powers do the PCA have on information? Well, Section 52 of the Small Business and Enterprise Act and Code and the Code Regulation 61, in the performance of the PCA is entitled to require arbitrators to promptly notify the PCA of any of the following: the capacity or availability issues which may materially affect the progression of the case, failure by a party to pay the arbitrator's fees on time. They do need to know this. You don't have a lien, but the PCA do expect you to tell them if there's difficulty in getting your fees paid. Frankly, that hasn't happened in my case. The FOBs know their obligations, and they do tend to pay quite quickly. They don't really want the PCA coming down on them and accusing them of non-payment. Challenges to the arbitrator's appointment or conflicts of interest that arise during the arbitration should be reported. Applications for correction of an award or an additional award under Section 57 of the Arbitration Act should also be reported to the PCA through the Chartered Institute. As an arbitrator communicating with the PCA, and when I say PCA, I mean the Chartered Institute of Arbitrators as well, who are acting on behalf of the PCA, can be electronically, so by email. You should provide the information requested and any updates as may be asked of you. An update should be quarterly, and I believe they're considering that to be reduced, but quarterly at the moment, as reasonably required. With regards to the status of the arbitration, including the total cumulative length of all periods for which the proceedings have been stayed. So if proceedings have been consistently stayed for 4 weeks and a further 4 weeks, so on and so forth, for 6 months or more, or whatever it might be, you should be keeping the PCA informed. Electronic copies of directions, pleadings, orders, and awards, including corrected or additional awards, should be sent to the PCA once issued. You should not be waiting until closure of the case before providing this information. It's all about sending information as and when it is generated. Of course, after the award has been written and you've dealt with the costs, you need to complete the closure form and provide this to the PCA on termination of proceedings. There's an update in PCA closure form, which I've noted recently that the Chartered Institute have been sending by email to everybody, so hopefully you will have seen that. It's not a difficult form to fill out. However, it has been amended to reinforce the fact that the arbitrator must update the Chartered Institute on behalf of the PCA immediately after any stay of proceedings have been granted in the case. This should include a start and end date for the period of the stay, and should be reporting using dates rather than periods of weeks. So if it's been a 4-week period, say, has been agreed for a stay, that should equate to a specific date. In the closure form, arbitrators will be required to complete a table recording all of the stays provided in terms of dates. Arbitrators' communications. You will correspond with the parties electronically unless otherwise agreed by the parties. Again, the process has not been set up for everything to be sent by post. Email is what's expected, electronic communication. You should be able to conduct hearings remotely where reasonably required. Clearly, you don't need an in-person hearing for a matter that's only going to take, well, maybe even a day, especially when the parties are a distance from each other, and indeed you as the arbitrator. You don't need the cost of hiring rooms for an arbitration for PCA arbitrations. It should be able to be conducted electronically unless there's a good reason why it needs to be in person. Obviously, your written correspondence and documentation is to be in a font type and size that's legible. They do suggest a minimum of 11-point font size. I think that is undoubtedly the minimum you should use. When you come to data, personal data, and commercially sensitive information, it needs to be kept confidential. It's not to be distributed. It shouldn't be processed widely, more widely than is required for the arbitrator's role. Personal data of the parties should be processed in line with relevant data protection legislation. You have to be aware of data protection law. You shouldn't act in any way to prevent or restrict the PCA from seeking to publish the arbitrator's award. They are redacted in any event. It won't affect your rights as arbitrator to refuse consent to publication of your personal data. It's the award. You can refuse personal data, but you shouldn't try and stop the PCA from publishing an award should they wish to do so. At the termination of proceedings, you as the arbitrator will act to show the parties any existing statutory process that continues, such as the independent assessor, because that process is separate from the arbitration. And if that process is ongoing, to make an appropriate order or award showing what the next relevant step is. So where the dispute relates to the compliance of an MRO full response, and the arbitrator has ordered a revised response under Regulation 33 of the Code, you should make appropriate provision in the award for the period in which the parties may refer any dispute about the compliance of that response to the PCA for arbitration. This is to ensure that the parties are aware of any time limitations that they need to be complying with, especially the tenants, who may not necessarily have the knowledge at hand. So it's helpful to all parties. We don't want a party to lose their rights simply because it's something an arbitrator didn't bother to mention. Where the parties reach a settlement on MRO terms, but wish to refer the MRO rent to an independent assessor, to make clear where the parties are on the statutory timetable, so there's an appropriate provision for a referral to the independent assessor. In most cases, and you would need to check that this does in fact happen, when you issue your award, if it's been a settlement, or indeed you found that the MRO is in fact compliant, you would normally have, the TPC would normally have 21 days in which to issue their notice for an independent assessor. But again, you do need to check to make sure what the compliance timetable is. The PCA also asks you to state your hourly rate as arbitrator. Bone of contention, perhaps, possibly, but the PCA do need to know what their arbitrators are charging. They haven't set a cap, but they do expect it to reflect the experience and the complexity of the arbitrator and the complexity of the case. The arbitrator should also make appropriate provision for costs in the case in accordance with the Pubs Code statutory framework, of course, and should include the undisputed costs of the PCA if applicable. The PCA says that it should usually be in a separate order or award from the substantive award, However, that's not necessary, in my personal view, if the costs can be dealt with in the substantive award without having to go back and make a further award. I see no reason why that shouldn't be done. But the PCA do themselves look for a separate order or award. The PCA performance measures are there to show how the PCA is performing against clearly defined standards, and in some cases to develop a baseline from which to measure change. The intention here is to help the PCA to identify areas for improvement, as well as being more transparent in the way that we as arbitrators work. The PCA will report on the measures annually. So they'll be looking at their own performance, they'll be looking at the performance of their arbitrators, if they are meeting the guidelines, and if not, they'll be looking into perhaps why aren't we? Do the guidelines need a change? But it's a way to make sure that our arbitrations that we're dealing with are being dealt with effectively, and if not, hopefully they will have an understanding of why and what the problems may be. The second statutory review of the Pubs Code and Pubs Code Adjudicator, covering the period from 1st of April 2019 to the 31st of March 2022, is being undertaken by the Secretary of State for Business, Energy and Industrial Strategy. They've started the review by considering a range of publicly available evidence. On the 26th of May 2022, Parliamentary Under Secretary of the Department for Business, Energy and Industrial Strategy, the Ministry of State, published an invitation seeking stakeholders' views and evidence which will be considered this review. So the stakeholders, the TPTs, the POBs, the PCA, the arbitrators, are being asked for their views so that a review of how the process is working can be undertaken. That is eventually, of course, will be reported. You can access the review through the gov.uk site, and the information that we're providing after this seminar gives a link, should you so wish to have a look at it. It is government, of course, so a report on the findings of the review will be published as soon as practicable and laid before Parliament by the Secretary of State. Of course, we don't know how quickly that's going to be, and it very much depends what other business Parliament may have to deal with. So there we are. It's a brief overview of the arbitrator standards, what's expected, why the PCA requests this information, and how it's used. Nigel.
Thank you, Bob. Please, could we have the next slide, Katrina, slide 21. So most arbitrations concern the MRO full response, and in this regard, the PCA has published accessible information in the form of a fact sheet, which has been updated as recent as 17th of May 2022 and is headed MRO Events 1st of April 2022 onwards. What tied pub tenants need to know about the market rent only rights. A link to which is included within the written materials to be made available to you after this seminar. From the 1st of April 2022, the CIArb's Dispute Appointment Service took over the administration of referrals from the PCA, who had previously dealt with these referrals in conjunction with the RICS and the CIArb. The PCA makes the final appointment of arbitrators. The referral fee is £200. On the 1st of August 2022, the PCA launched its three-year strategy, in which the PCA outlines the focus of its priorities for the next 3 years in relation to rebalancing the tied pubs trade. There are 7 elements to the PCA success criteria, and these include: 1, tenants are aware of their rights and legislation to support them. 2, that tenants know what information they're entitled to and when and how they can access their rights. 3, tenants know what their options are if they are not treated fairly and know what steps to take to address that. 4, pub owning companies are clear on their obligations within the code to empower tenants throughout the tenant journey by providing the right information, dealing fairly and in negotiations, and informing tenants of key moments to access their code rights. 5, that pub owning companies are clear on the process for raising issues that might affect their obligations, how to flag code breaches, and the consequences of not doing so in a timely manner. And 6, the PCA partners with a wider sector to promote understanding of the code for key stakeholders, including legislative changes and responses to key strategic issues that arise. And 7, tenants and pubs receive a quality arbitration service to resolve code disputes, and tenants have access to quality professional advice to support them during their business relationship. Could we have the next slide, please, Katrina? So I would leave it to you, Bob, to recap.
Okay, here we go. Yes. Recap. Well, today's training session, I guess is the right word for it, was an introduction to those arbitrators who have not undertaken PCA arbitrations before, and just as a recap for those who have been undertaking them for a while, and to make sure that everybody is up to date and understands the requirements of PCA. So at the end of this session, you should have had or should have gained an understanding of the Pubs Code statutory framework, including the aims and core principles of the code and the hierarchy of laws, including the distinction between MRO and non-MRO disputes and the applicable time limits. You should be able to identify the relevant considerations specific to the Pubs Code statutory arbitration scheme, including the treatment of costs. You should know what is required to adhere to the Pubs Code arbitrator standards and the reasons for this. And finally, be aware of the existing PCA advice, guidance, High Court judgments, and where to find future publications. All of this information will be in the notes that are sent around to you. And of course, a great deal of it is on the PCA website itself. Hopefully, we have been able to quickly, admittedly, take you through how the PCA arbitration works, what aspects you should be looking for, especially if there's questions about timing of referrals, when did a dispute occur, notices, so on and so forth. When you read the regulations, these can look a little bit complicated, but the guidance provided and the flowcharts provided are quite useful in actually working out what the timings should be. Now, these are still arbitrations. The Arbitration Act itself is, of course, applicable. There was a question with regards to the costs of arbitration, and could we do the usual of costs follow the event. But because there's the specific fees regulation with regards to the Pubs Code arbitrations, these take precedence. And it's quite clear that how you should award your costs and the sort of costs that you can award, and they should be followed. If you go off and simply follow the normal rule of costs follow the event, you could find yourself in some difficulty. So at the end of the day, hopefully you've, as I said, got a better idea of how you should be approaching any arbitrations that you are asked to conduct. And unless there's any particular issue that you would like either Nigel or myself to cover again, I don't wish to bore you too much longer. but we're happy to take questions that you may have.
And I thought that was extremely helpful, and thank you both very much.
Thank you.
Thank you. And I should point out that, of course, you'll be getting the exam paper with 50 multiple choice questions on it. I believe you're going to be given 3 hours with which to cope with those 50 questions, but you've got a 3-week period within which you can actually sit down and decide to do those. The pass mark is 80%, so you need to get 40 of them correct. Good luck to everybody. I suspect you'll all do perfectly well.
Thank you, Bob, and yes, very well done and very helpful. But I just wondered if it may be helpful to everybody to clarify a few matters relating to the issue of worse off, because I was the arbitrator on the Clark case.
Yeah.
And it is interesting, and I always have sympathy for the judge that has to deal with something that's been remitted to them as appeal. But what was interesting is that the parties both argued in the first instance as to whether the proposed new lease was worse or better than the existing lease.
Yeah.
And in dealing with that particular subject matter, I did say, and very clearly, that the proposal was either better or worse. And I did it in both ways than the existing lease, because what Fiona Dickey did make clear in her legal assessment of the position of what is worse, she did make it clear that the existing lease might have to be the benchmark. And if you look at it, I think the existing lease does have to be the benchmark, first of all, to establish the change that's being proposed in the lease terms, and secondly, to establish if it is better or worse than the existing lease, and then look at what the market says. And the reason I put it is it could sound as if I'm being defensive. I'm not, because I think with hindsight, I might well have been able to word it better to avoid it. But I think both parties were itching to get at this whole question of what is worse off. What does it mean? Because it had been particularly unclear. But the learned judge, I will say, in the High Court did say that, well, actually, the arbitrator did then go in to the detail as to why the new term should be rejected or not, which is when I then looked at what was happening in the market. And it was against that background then the judge said, well, there was an error of law because of the way he interpreted what I was doing. But then he did not allow the appeal because in every case that was raised, I dealt with the position of the market and whether that new term should be acceptable or not. So the reason I put it is because this whole question of worse off is quite a vexed one. You do have to identify where the starting point is, and it must be if there's a change to the existing lease, in my view, and then to see what it is the change, and then to see where the market is. And that was my approach. But my downfall was not making it clear enough in my wording to avoid it, and I should have known that the parties were itching to get at that subject matter. But at the end of the day, I think it was very helpful for the whole matter to be examined and a judgment given. So I promise you it's not meant to be defensive, but it is, Bob, trying to be helpful to look at how you have to deal with these matters, particularly if you're a mere estate agent rather than an honest and detailed lawyer.
I wouldn't call you a mere estate. However, you are right. It was the particular wording in the statute that vexed the judge, as I recall, and he decided you couldn't just simply look at the original lease to see if it was in a better or worse position with the MRO position. You had to look at the market, when I read that judgment, I asked myself, well, okay, how am I meant to look at the market if the information isn't provided to me? So there are going to be issues there, but I think that judgment is very helpful, despite the fact that there was some criticism, but I don't think it reflects on you at all.
No, I agree. It was very helpful.
Mhm.
And the criticism I found useful because it put it into a clearer context. It's just that if you're going to find out whether it's worse than the market, I still think you have to look at the existing lease to see what the changes are.
You can't.
It was interesting to me the judge didn't even bother to do that, which I thought was a bit surprising. But I did follow his thought process. It's a very clear judgment, and I absolutely accept most helpful.
Absolutely.
Yeah, can you hear me?
Yes.
Oh, good. I can't find my settings button. A very pragmatic question coming from the point of view of someone who has no experience of this at all. In terms of party representation, is it a normal or usual pattern that the tenants are not represented parties, or do you usually have both parties represented?
I think it does vary. I've seen the pub owning businesses inevitably are represented by solicitors firms.
Mm.
And normally large ones.
Yeah, and large ones at that, yes. The tenants occasionally are represented by solicitors. Occasionally they are represented by consultants, for want of a better word, who tend to be ex-publicans who have got into the business of dealing with code arbitrations. And there is some difficulty there because they're not necessarily arguing or making submissions in the same way a solicitor would. And they certainly aren't necessarily going to be up to speed with the law. And occasionally you do get a tenant just representing themselves. So there is a variety. And I think as the arbitrator, you need to be very careful in making sure that there's as level a playing field as possible without helping the tenant to make their case. And that can be quite difficult at times when you're trying to say, this is the process, this is what you should be doing. Do you think you need an expert? This sort of thing. But you can't lead them by the nose.
And can I ask just one follow-up? Given that difficulty, and I know there's a lot of people on this seminar who have experience, I just would be interested to know whether there's any, or what the scope is, whether it's used for using single experts rather than relying on experts that a party not represented by a lawyer might instruct.
I'll open that to the floor, but in my experience, I've not had a single joint expert.
I have not either. No.
Okay.
Does anybody?
Thank you very much. Thank you.
No.
Got a question?
Please, I'm doing it on the chat and no one's coming back to me. What happens if we don't pass? Can we take it again?
I don't know the answer to that.
That's why I haven't got an answer.
Katrina, are you there?
I am here. I haven't got an answer, but I can find out and email for you after we get off this call.
Thank you. Yeah, my experience is that there are these, as Rob, as Robert Slawinski says, there are these consultants out there. There's 2 or 3 of them who have a plethora of these pub tenant clients, and these guys are not lawyers, and they're not au fait with the law. They think they are au fait with the statutory requirements. I don't think they are in particular. And what you will find is they're a little bit slow sometimes in coming back to you when you're asking for their comment on a particular application. So you'll find that in my experience, others may be very different, but I found that I had to continually chase them for a response because the pub owning business solicitors will make an application and they'll deal with it pretty efficiently. But these are, as Rob put it, one in particular is a publican and isn't always available. So you will find your admin is starting to go a little bit awry. Okay.
Thanks. So you avoid opening hours, do you? In which to drive? Okay. I'm beginning to get the picture here. Okay. Thank you.
Can I disagree with? I have familiar with 2 of the representatives who appear regularly, and I find them pretty on the ball. So.
Horses, I suspect, Ben. So does anybody else want to raise anything or say something?
Can I just add one thing about that? I find that there's a huge amount of advocacy in terms of representation rather than the representations of an expert witness, and that can be quite tricky at times. But just in terms of them taking that position, I find now that both parties are very happy to continually agree to serial and ongoing stays. And I appreciate that the eyes are burning through the page looking at me from CIArb and the PCA. And on what I've recently done is I said, well, I've given you 3 or even 4 stays, and I will now, if I don't hear back from you, or if you don't agree the position by this date, I will issue directions as to the process, so that at least I can demonstrate the proactive approach. But it isn't just one side. Now, of course, I don't know in terms of the pressure from either the pub operating company or the tenant as to who's got the whip hand. And anyway, I think it changes with the market. I can't see where the problem lies, but if both parties are prepared to agree to stay and they keep saying, well, it will help us come to a mutual agreement and settlement, well, it's a very dangerous thing to do, to take a different approach. But that's how I've had to deal with it. I threatened to issue an order on the basis that as soon as I do that, of course, their cost will increase. And that sometimes helps. Anyway, or the costs, usually nearly always of the pub owning company. But I have found that as a real problem between the parties now, against this new set of requirements of the PCA. And of course, I did put in my notes that I'm finding it takes an extra 1 to 3 hours now to deal with these new administrative procedures in terms of each case. And of course, that in theory is the cost down to the parties.
Yeah, that's true.
Okay. Excellent. Well, thank you very much, everybody, for attending and staying with us throughout the afternoon. And, well, best of luck with the exam. My personal feeling is you shouldn't have any real difficulty. You're all well-versed arbitrators and you know what you're doing. So I don't expect any failures. Good luck.
Good luck, everyone.
Cheers.
Thank you.